next matter to come before the court this morning is Grubb and Associates LPA versus William Sandor. Good morning. Each party will have 15 minutes in which to present their case. As the appellant, you may retain up to 5 minutes for rebuttal. If you wish to retain some of that time, let me know. When you come up to the podium, I'm keeping track of the clock and we'll keep you apprised of the passage of time. We are being visually and audibly recorded and be posted online, so please try to remain behind the podium as much as possible. We have read your briefs and we're ready to proceed when you are.
Thank you. I would like to reserve 3 minutes for rebuttal.
Thank you.
May it please the court, my name is Mark Bowens. I'm the attorney representing the appellant in this case, Grubb and Associates LPA. This appeal concerns preservation and enforcement of a written hourly retainer agreement with a handwritten modification to ensure that Mr. Sandor received the best possible bargain. If he was fortunate enough to receive a recovery, then he would have the option of paying the lesser of the hourly fees that have been billed by the firm, or he could pay 33% of the amount recovered. At the same time, this alternative billing arrangement provided assurance to Mr. Sandor that the firm would not receive a windfall in the case of an early case resolution or a small settlement or small recovery, while providing assurance to the firm that it would in fact receive compensation for the time and the costs expended in representing Mr. Sandor. Now, just by way of quick background, Mr. Sandor came to the firm because he had suspicions that his former counsel had committed malpractice in a domestic matter. He came in, and as is customary, he filled out a client intake sheet. On that client intake sheet, he indicated the nature of the matter as being legal malpractice, and then he indicated the date range when his former counsel had represented him, March 2010 to November 9, 2011. The firm then calculated the one-year statute of limitations based on his representation that the representation had ended with his prior counsel on November 9th. They then filed the legal malpractice claim on November 8th the following year, within that 1 year. Unfortunately, it turns out that Mr. Sandor provided the wrong information to the firm, and there's a later affidavit that we've moved to correct the record and submit that we filed late last week because we had filed only the first page of his affidavit attached to our reply brief in the summary judgment briefing below. But the complete affidavit on the second page contains his admission that in fact he knew that his counsel was terminating the representation on November 7th. 2 days before. So just by way of background, because this has come up, that there's been an allegation that somehow Grubb and Associates malpracticed him and that the only reason he didn't get a recovery is because his legal malpractice claim wasn't filed on time. That's absolutely not true. The reason he didn't receive a recovery is because he provided the wrong information to the firm and he caused his own claim to be filed out of time. Now, most importantly in this case, we have a written hourly retainer agreement, which is in the record, which I'm holding up now. This hourly retainer agreement sets forth the hourly rates to be charged. It provides for a retainer to be paid before work begins, which Mr. Sandor paid. There's an agreement to separately pay costs and expenses dispersed in addition to the attorney fees. It provides for monthly billing statements, and it requires that all statements are payable on receipt, and even provides the firm with an attorney lien for all amounts that remain due and owing when the representation terminates. Now, these terms directly contradict Mr. Sandor's argument in his appellate brief that there is no provision in the agreement that guarantees Grubb and Associates payment to the firm in the event of no recovery. That's absolutely incorrect. Mr. Sandor understood that he would owe fees to the firm, either on an hourly basis or on a percentage basis, depending on the amount of any recovery. He stated in his deposition, and it's quoted throughout our briefing, he stated, quote, "It was in my benefit, even more than a straight contingency," which is important, even more than a straight contingency, because even if we did win, and there was a settlement, and the hourly rate was less billable than the 33%, I would have to pay even less, he says. This understanding is consistent with the express terms of the hourly retainer agreement as modified by the language or percentage at 33%, whichever is less. Also consistent with Ms. Grubb's testimony, where she stated that the concern was to give Mr. Sandor the best deal possible.
Was this, So I'm wondering about the statements being made outside the contract being relevant to the argument that's being made that it's unambiguous.
Well, our argument is that it's clearly and unambiguously an hourly retainer agreement with this handwritten modification.
Excuse me, but the modification says or.
Right.
It doesn't say unless, it says or.
Or 33%, whenever it's less.
So how, explain how who wrote the notation?
That was written by the firm at Mr. Sandor's insistence because he was concerned about the windfall being given to the firm if the case will settle quickly or if he received a small amount. So it was considered to be the fairest way to allocate the risk to both parties. But in no way was it ever contemplated that the legal work would ever be free. And the reason why we know this 33% doesn't mean 33% of zero is because you can even look to the trial court's inconsistent summary judgment rulings. They use the same language in both rulings up until the point of their decision. The trial court says in denying the firm's motion, it finds that the agreement is that he will pay hourly or 33% of, quote, any amount recovered, end quote. They use that language, any amount recovered, in both opinions. So even the trial court understood that there had to be a recovery before the 33% would even become relevant. The facts between the two opinions were exactly the same. There was no change in the facts between the time summary judgment was denied to the firm and summary judgment was granted to Mr. Sanders. The same agreement, same language. They interpreted the payment arrangement the exact same way in both cases, except in the second opinion, they add the language, after the amount recovered, they add, quote, whichever is less, comma, thereby forming a contingency agreement. So that was new. So now the second time around, the trial court says it formed a contingency agreement. Didn't rule that way the first time. The first time, in denying the firm's motion, the trial court found genuine issues of material fact and could not determine what was
As to
owed.
the amount owed, right?
As to the amount owed. But you must ask if it was a contingency agreement the way the court interpreted it the second time, why would there have been a genuine issue of material fact as to the amount owed? Because it was well known that there was no recovery on this claim. So there shouldn't have been a genuine issue of material fact as to amount owed if that was what the court interpreted the contract to be, a pure contingency agreement. The trial court with the second judgment, for the first time, holds that there are no genuine issues of material fact. That's directly contradictory to the first holding. And that reasonable minds can come to one conclusion: the Sandor is entitled to judgment as a matter of law. So
Now,
again,
was there additional discovery or anything new before the court in between the two rulings?
there was absolutely nothing new before the court. It was the agreement, the same deposition testimony of the parties, same facts, same deposition testimony. The court just interpreted, it came to a completely opposite conclusion with the second summary judgment ruling. There is no logical or sensible way to reconcile the trial court's two summary judgment decisions. Finding genuine issues of material fact in the first order as to the amount owed, and then finding no genuine issues of material fact in the second order, finding the agreement to be clearly and unambiguously a contingency agreement, simply cannot be reconciled. They're directly contradictory.
Was that argument raised in the first motion for summary judgment by the Mr. Sandor?
Yes, he made the exact same arguments in
Yes.
opposition to the firm's motion as he made in support of his own motion for summary judgment. No difference. Court had the same agreement with the same handwritten language in
The burden
front of
was
it.
different when he's defending it, right?
The burden is different. But if the court was going to interpret this as a clear and unambiguous contingency agreement, it could have done that the first time around if that's.
Well, if when they're arguing the summary judgment motion, if they haven't met their initial Drescher burden, then it just ends there, right? On the first time when they denied it. Whereas if the other side files and meets the Drescher burden, then it comes over to the other side.
Well, I would agree, except with the first opinion, the court didn't hold that we didn't meet our burden of establishing the contract and what the contract was, the court just said, we can't determine how much is owed. That was where the genuine issue of material fact was. And there would be no issue as to the amount owed if this was a strict contingency agreement, because there was no zero recovery. I mean, there was zero recovery, so there wouldn't be any amount owed. So, and if anything, between these two opinions and then looking at the contract, if the handwritten language was going to do anything for the trial court, it should have ruled that the contract then was not clear and not unambiguous, and allowed the testimony to come in to find out what was the intent of the parties entering into the agreement. And that could not be more clear. Both sides testified as to what was intended in entering into this contract, and it was clear that what was intended was the firm would be paid either hourly or the firm would get 33% of their recovery. Zero is not a recovery. And that's also consistent with the trial court's language again, where they say the trial court uses the same language of any amount recovered. Also, Mr. Sanders' quote that I read to you, the language, quote, more than a straight contingency, end quote, and, quote, I would have to pay even less, end quote, would be meaningless if, as the trial court held in its May 31st, 2018 order, Sanders signed only a pure contingency agreement. Clearly, Mr. Sandor understood that his arrangement with the firm was not a contingency agreement, because he understood that even if he won, and there was a settlement, he could still fall back on the firm's hourly fees if it was to his benefit. He could pay the hourly fees instead of paying 33% of the settlement amount. So there was no factual or evidentiary basis for the trial court's determination that the parties' agreement was a straight contingency agreement, when in fact the clear and unambiguous terms of the agreement itself, again, it's a very detailed hourly retainer agreement. The only difference is there's a handwritten term or a percentage at 33%, whichever is less.
Which creates some ambiguity, doesn't it?
It could create some ambiguity, and I would argue that if the trial court was going to do anything, that's the way it should have gone. It could have said, okay, we have this handwritten note. So this agreement we should find to be ambiguous, in which case we're going to bring in evidence outside the contract, and we're going to determine what was the intent of the parties. All that evidence points to appellant's argument of what the agreement meant. There's absolutely no evidence that there was ever any intention that the work would be done for free in any scenario. This mutual understanding was further corroborated by the affidavit of Laura Zetz, who was a third-party former staff member of the firm. That affidavit was submitted to support the motion to vacate judgment. She was the only other person in the room when the parties met for that initial client meeting. She testified in the affidavit. Ms. Grubb fully explained to Sandor that she was accepting the matter on an hourly basis, and that as an accommodation to Sandor to assuage his fear that the firm might receive a windfall should the matter be settled or judgment be rendered quickly for a large sum, she graciously agreed that Sandor could pay the lesser sum between what the firm is owed hourly under the retainer agreement and 1/3 of the sum awarded or settled for. At no time was there ever any discussion that the firm would do the work and not receive any payment for the time.
You're down to 2.5 minutes
Okay,
total.
thank you. 2.5 left?
Before your 15 minutes is up.
Okay.
So you're into your rebuttal.
Right. I'd like to save that for rebuttal, please.
May it please the court, Mr. Owens. I'm Scott Bellman. I'm here on behalf of appellee William Sandor. There are some key points that I feel need to be made and need to be stressed when we're looking at this contract and what the trial court did. The first key is the handwritten notation on the contract, as the court pointed out, said "or." And also that handwritten notation on the contract is not in dispute. The parties have agreed that that is a term of the contract, despite the fact that it's not typed. argument that there are contradictory rulings from the trial court, I don't think is accurate. I would state that when a motion is brought before the court, like was in this case, and as Judge Hensel pointed out, there is a certain standard under Drescher that needs to be addressed. The appellant filed a motion for summary judgment relying on the contract document, stating that the contract document established a written contract between the parties and entitled the appellant to money under that contract and under an hourly fee provision. Mr. Sandor, in response, noted that the motion for summary judgment that was presented by the appellant, by the plaintiff in that case, wholly neglected to even address this handwritten notation that was on the contract. No mention in the motion for summary judgment of this provision. The motion rather stated this is a clear hourly fee agreement and did not address the pertinent handwritten notation. So when Mr. Sandor responded, as he should have, he raised the material issue of fact. The issue of fact that he raised was, wait a second, there's no mention in that motion. This handwritten notation is not addressed in that motion. And that affects the amount of recovery. Because if that handwritten notation was the contingency arrangement that Mr. Sandor has alleged all along, there would be zero recovery. And the plaintiff in that case, the appellant, in its motion stated that under the hourly agreement there was this almost $14,000 due. So when we talked about the trial court finding an issue of fact as to what was owed, that's why the court found there was a material issue of fact. Mr. Sandor just pointed out that there was some language that was not mentioned in the summary judgment motion. Mr. Sandor then filed his own motion. Now the focus of his motion was different. Mr. Sandor indicated that this contract is clear. When you look at that document, the several pages of that document, it is clear. It says, here is the hourly rate breakdown of hourly rate charges, or a percentage at 33%, whatever is less.
Well, if he thought he was getting a contingency fee contract, why didn't he just sign a contingent fee contract?
Well, as was indicated,
I thought it was an hourly agreement.
I apologize, Your Honor. As was indicated in deposition transcripts, when Mr. Sandor went in, he had a signing appointment at Grubb and Associates' office. When he went in with his then girlfriend to sit down and they presented this for him to review, he started reading it and said, wait a second. You know, I contacted you and confirmed this was going to be done on a contingency basis. This is hourly here. And that's when the handwritten notation was added in, and Mr. Sandor decided that, okay, he's covered and he's going to sign that arrangement.
Now, what are we going to find in the record that supports what you just said?
The deposition transcripts of Mr. Sandor.
Okay.
And also, I believe his girlfriend's deposition had been taken as well, Cynthia Brooks. I don't recall right offhand, I don't have the docket as to whether that transcript had been filed, but regardless, Mr. Sandor's deposition will explain what happened when he went to sign. Getting back to Mr. Sandor's motion for summary judgment, he indicated that this was clear. Hourly rate on one hand, or 33%, whatever is less. It was clear, it was unambiguous. You don't have to get into these deposition transcripts, these explanations, these Ms. Zetz, who was brought up only in an attempt to vacate a judgment that had previously been granted. There was no affidavit or testimony from her at any point prior to that. So upon that assertion, you know, the court was able to look at the document, look at it on its face, and the case law that was cited indicated and established that if you know, the document is clear on its face, and it's clear as to what the arrangement was, then you don't even get into all of this stuff. And the court found that here is the arrangement, hourly rate or 33%, whatever is less. And there was no recovery in the action. On behalf of Mr. Sandor, I would submit that it wasn't in the prior action, it wasn't Mr. Sandor's responsibility to establish a statute of limitations or a milestone date for that purpose. I think appellant suggesting that the prior case failing and being of no recovery just needs to be addressed in that context. It falls on us as counsel to determine when a statute begins to run. I think the court got it right. I don't think we need to get into all of the extrinsic evidence, the parole evidence. I understand the appellant wants to do that. I think that the court got it right in this instance. The case law that was submitted to the court in the motion for summary judgment that the court relied upon as well discussed or got into in the court's decision as well, talked about attorney-client type arrangements. And some of the case law that I had cited was more from disciplinary actions, but the theories carry over in terms of the issue of the quantum merit or the unjust enrichment that's being sought. If there's no recovery, there's no claim on a contingency arrangement. If there's no recovery, there's no claim for the unjust enrichment or the quantum merit. That usually comes up in contingency agreements when counsel is discharged, and then there's a recovery later as to when that principle would apply and allow prior counsel to share in or receive the quantum merit portion of that recovery. But the principles still hold true that you cannot have a contingency agreement with a client as an attorney and attempt to then extract an hourly rate billing under the disciplinary cases cited in support of these propositions. So I just think that the court was able to look through and see what this was. I would submit that these types of cases should be construed in favor of the client, especially in an attorney-client relationship. And this was clearly an either or. And we look and we see, was there a recovery? There was no recovery. The appellant should get nothing. And I think the court saw it. I don't think it was contradictory. The court discarded all of the parole evidence, all the extrinsic evidence, and focused on the contract and on the agreement itself, and found that this is a contingency arrangement. Regardless of whether there was regardless, I guess, if there was a provision in there that whatever would benefit most, it still presumes there has to be a recovery. Or why have a contingency arrangement if why even put that in there? So I just think that in this case, the court should be upheld. I know this is contract interpretation is a de novo review. I think if you look at the document itself, it's clear that there should not be an attorney fee owed on this case, and I think that the trial court got it right. Thank you.
Thank you. We have about 2.5 minutes left.
Yes, thank you. First, as to the argument that the 33% can somehow stand on its own, you can't just take that 33% handwritten clause. That would never be able to stand on its own. What it does is it modifies that entire hourly fee agreement. And the court did not find that there was a fact issue as to the hourly fee billing versus 33% of amount recovered. Trial court made it very clear that it understood the terms of the agreement. There was no hiding of the terms of the agreement as is implied. I mean, it was briefed extensively in our reply brief, as a matter of fact, that specific language, the 33%. And the court concluded that the contract called for an hourly rate system based on billable hours or 33%, quote, of any amount recovered, end quote. It couldn't be more clear.
So if $1 was recovered, the fee would have been 33 cents?
Yes. Absolutely. Had there been any positive recovery, you can't have, that was what I was gonna say next, is 33% of what? There has to be something to take 33% up. It's nonsensical to say you can pay the lesser of our hourly fees or 33% of zero if you get a zero recovery. If that was the case, as was mentioned by Judge Teodosio, why not just do a straight contingency contract? That wasn't done, and that wasn't contemplated by the parties. Also, there was a mention of Mr. Sanders' girlfriend. His girlfriend testified that she could not remember anything about the contract. It's been our contention that she was not there. She could not substantiate that she was actually there at the meeting. Attorney Grubb testified that she was not there. So there's no evidence that there was any other third-party witness to the actual transaction and signing of the agreement other than Ms. Setz and Ms. Grubb.
Remind me, was Setz deposed or not?
She was not. She was not. We submitted an affidavit.
That was just the affidavit.
Right. There was also a mention of unjust enrichment. We're not arguing unjust enrichment in this case because we have an express written contract, so we don't need to get to unjust enrichment. Unjust enrichment is an alternative claim when you don't have an enforceable written agreement that covers the transaction. And here we do have a written agreement. I presume my time is about up. So I thank you all very much for the time today.
Thank you both for your presentations today. The court will take the matter under advisement. Initial decision, which will be mailed to both sites, as well as posted to our website and that of the Supreme Court. Thank you.
Thank you.